Welcome to the UNSW International Open Day 2020 seminar program, coming to you from the stage at the Clancy Auditorium at our Kensington campus. I'd like to begin by acknowledging the Bedegal people of the Aurora Nation that are the traditional custodians on which UNSW Kensington stands. I'd also like to pay my respects to elders past and present and extend that respect to any Aboriginal and Torres Strait Islanders who are joining us here today. My name's Christine Forster, and I'm the Associate Dean International at UNSW Law. Our speaker today is Professor Lyria Bennett-Moses. Lyria is the Director of the Allens Hub for Technology, Law and Innovation, and she's also a Professor in the Faculty of Law, exploring issues surrounding the relationship between technology and law, including the types of legal issues that arise as technology changes. It's a real pleasure to introduce Lyria today to give her talk, Artificial Intelligence Judges, an Inevitable Future.
So, artificial intelligence judges. Now, artificial intelligence is not necessarily a very useful word, but it captures techniques like expert systems, natural language processing, and machine learning. And these tools can be used to automate some tasks traditionally performed by judges or lawyers. Start with an expert system. This is basically just a decision tree or a series of if-then statements. And I teach a course for students on how to build these that you can do towards the end of your degree if you're keen. But the most important thing that students learn is their limitations. So expert systems are great for, was the strip search to which I was subjected at a music festival legally conducted? But not for, am I in a de facto relationship or was that conduct negligent? It cannot decide whether something that takes into account a broad range of factors with no fixed weighting is true or not. So then we come to the more advanced techniques, things like natural language processing, which can parse text and really does help improve searches, making it easier to find relevant cases. And machine learning, which is where you're using data to train an algorithm to learn something, perhaps to guess the outcomes of litigation based on a range of variables. Combined, could we use these techniques to input all the judgments, all the case law, and output a decision in a particular case? Well, some people, and some companies in particular, claim to be able to do something pretty close to that. The company Lex Machina claims, and I'm quoting, "We mine litigation data, revealing insights never before available about judges, lawyers, parties, and patents, culled from millions of pages of intellectual property litigation information. With Lex Machina, you can easily view how likely is a judge to grant or deny a specific motion? How long do cases take to terminate or get to trial? How likely is a judge to find patents, trademarks, or copyrights infringed, invalid, or unenforceable?" Sounds pretty good, right? But how useful is this kind of tool really? The biggest problem with it is, what cases is it mining? If you limit yourself to cases that are actually decided in court by a judge, then you've got a very skewed sample in your data because most cases don't go to court. But if you include cases that don't go to court and you're including all the settlements, how do you know that they reached the same outcome they would have got had it gone to trial? In other words, I wouldn't bet the house on the predictions of a system like Lex Machina. But are these actually used in practice by judges or to replace judges? Well, the closest thing so far is the use of risk prediction algorithms for sentencing in the United States. Judges there use a tool called Compass, which takes in a whole range of data about reoffending patterns of people who've been convicted of a crime, sent to jail, and then released into the community to try to predict whether a particular defendant in a particular case will go on to commit a crime, and then use that information in deciding how that person will serve their sentence. For example, in a case of State and Loomis, which was in the Supreme Court of Wisconsin, at trial level, the judge had said, and I quote, you're identified through the Compass assessment as an individual who is a high risk to the community. In terms of weighing the various factors, I'm ruling out probation. Because of the seriousness of the crime and because your history on supervision, and the risk assessment tools that have been utilised suggest that you're at extremely high risk to reoffend. Now, the Supreme Court in that case had to decide, is that okay? Is using this kind of data-driven inferencing, this machine learning tool, a good way to decide how someone should serve their sentence? The Supreme Court concluded that because the trial court did not rely solely on the risk assessment score and only used it in its determination regarding probation, the defendant's right to due process was not violated. In particular, the court noted that while Loomis could not actually challenge the process through which the score was reached, they couldn't challenge the machine learning algorithm because it was a trade secret of the relevant company. Nevertheless, it pointed out, the court was provided with appropriate warnings about limitations. Loomis was given the opportunity to verify some of the inputs into the algorithm, and he could challenge the overall score by arguing that other relevant information should be taken into account. Now, there was an interesting discussion about the extent to which the defendant's gender affected the outcome. So Loomis was male, and the way the algorithm had looked at all the data, it had concluded that men were more likely than women to go on and reoffend after being released from prison. So his score was higher because of his gender. Is that okay? Well, on that point, the court agreed with the state's assertion that gender as a variable promoted accuracy, given men and women have different rates of recidivism or reoffending and different rehabilitation potential, so that a gender-neutral risk assessment would provide inaccurate results for both men and women. Thus, it said, okay to discriminate on the basis of gender. This leads to a related problem, which is particularly acute in the United States, of racial discrimination. So this tool, Compass, has been shown to be discriminatory. And in particular, and you've got to listen to this one because it's a bit complicated, African Americans are more likely to get a false positive. In other words, if you are African American, it is more likely you'll be rated as high risk, even though you would never have gone on to reoffend, compared to a white person. So there's a different impact of using this algorithm on the African American population as compared to the white population. Is that okay? Now, other problems as well. If you look at the questionnaire used in this tool, it asks a whole range of questions. One of the questions it asks is whether your parents are still together, and if not, how old you were when they split up. In other words, if your parents divorced when you're at some kind of critical age, you're going to have to serve your sentence differently. Is this the right kind of decision making? Is this how we want courts to go about making sentencing decisions that affect people's liberty? Well, we can ask a range of questions as lawyers about this. Some of them relate to due process or natural justice. What does it mean to be able to challenge the output of an algorithm that you can't see? That you're not allowed to understand how it works? Sure, you can absolutely challenge the final score. You can say, yes, the algorithm says I'm high risk, but I'm not really, believe me. But is that going to work? Is a judge going to take your word over what looks like an objective, scientific process with a number rating? Probably not. In the face of computer says dangerous, individuals don't really stand much of a chance. Transparency is a big problem here. And in the Loomis case itself, one of the three judges in the Supreme Court was concerned about the lack of transparency and the fact that the algorithm was a trade secret. But we have to ask even bigger questions. Even if you could see the algorithm, is this the way we want these kinds of decisions made? Is statistical reasoning appropriate to a decision like sentencing? Should someone serve their sentence differently because people like them, according to relevant variables, behaved in a certain way in the past? What do we do about discrimination? Now, it sounds easy to fix, right? Can't we just build a different algorithm that doesn't discriminate on the basis of race? Well, maybe we could fix that problem. Maybe we can create an algorithm that doesn't have a differential false positive, but it would create different forms of discrimination. So one of the things about the COMPAS algorithm is that it treats people of the same race equally in terms of the score given. What do I mean by that? I mean that if you get a score of 7, say, your risk profile is the same whether you're white or African American. Now, how is that consistent with what I said before about the differential false positive rates? But not only is it consistent, it's actually mathematically impossible to be fair on both counts at the same time whenever you have a different pattern of offending among two different communities. In other words, which fairness metric? We can say we want a fair algorithm, but who decides what fair means? What is the right mathematical test for fairness? Another problem is if we start using algorithms like this, what happens over time is we get feedback loops. So let's suppose a certain kind of offender is always released early and a different kind of offender spends longer in prison. Well, we know that people who spend longer in prison are more likely to go on and reoffend. So the next generation of data will show those people as reoffending. It will confirm the initial correlation. And not only that, it will enhance the initial correlation. So the future becomes exactly a sort of ever-evolving snowball from the past. The data is also skewed. What data are we inputting into this algorithm? How do we know who's gone on to reoffend? Do we use arrest data? Well, some of the people who were arrested never committed the crime. Do we use conviction data? Well, that's not a very accurate mirror from the crimes that have actually taken place either. We don't actually know who commits crimes. We only know who gets caught up in the system. And we also know, particularly in countries like the United States, that that is itself racially skewed. Another problem, causation is not correlation. And I'm sure you've heard that statement before. It's very easy to say. But there's a difference between using something like the fact that you've been violent in the past to say that makes it more likely you'll be dangerous in the future, to using, which is a causation issue, to using something that's mere correlation, like the fact that you live in a neighborhood where dangerous people also live. Now, your living in that neighborhood might be correlated with dangerousness, but should that lead to you being treated differently by the state? So, what we have seen is a whole range of really complicated questions. It's not as simple as let's do machine learning, right? There's a lot of really hard questions to ask about what kinds of tools are appropriate for use in particular contexts, right? Some of them are about accuracy, and we've talked about the ways in which the COMPAS algorithm might fail on that front. But some of them are also about fairness, and some simply about what justice means, what we want to happen when you go in a courtroom. So, a bit of a sort of dystopic vision, if you like, of what artificial intelligence judges might look like. But let's return to the reality. How do we predict the future? Well, I like to think of this problem along 3 dimensions. Okay, so the first dimension is what problems can we solve now using these kinds of artificial intelligence techniques? We can do a number of things that would make the justice system more efficient. We can provide legal answers to simple questions. I'm sure all of you have a range of questions about the law, some of which depend on really simple laws, right? Questions like, does my landlord have a right to send me this letter, right? A lot of those kinds of questions, we can actually build expert systems, exactly those tools that I teach students to build in an elective, right? We can build tools to answer those questions for people, or maybe save them needing to go to a lawyer or, heaven forbid, go to court. We also use AI tools all the time. Whenever you do a search for a case using a legal database, the search is made more accurate and efficient by virtue of natural language processing and other artificial intelligence techniques. So lawyers use AI all the time. So these are the sort of what problems can we solve now, right? And we're already using AI in a number of ways. So my second dimension is what capabilities are out there that we could use to do things better? And there are a number of these. One example is a way of thinking about legislation that's currently being developed in a number of governments around the world, including New Zealand, New South Wales and Australia, and France, interestingly. And this is the movement called Rules as Code. The idea is legislation is often automated, right? But it's automated externally by other people, private companies and so forth. What if we can draft the legislative rules and the code at the same time to ensure that the code used in systems to make decisions about people corresponds with the rules in legislation? Can we do that better? Absolutely, right? So that's another capability that would let us do things better than we are now. A second one is legal prediction engines that I spoke about. Not to replace judges, but to give people a better sense of when it's worth incurring the costs of litigation. Now, the final question is really the hardest one. What is appropriate? And this is a really hard question on this third dimension. What we've seen, or what I hope I've convinced you of, is we need to be very careful about the use of data-driven inferencing and machine learning in making decisions that affect individuals. This is an area for extreme caution. But what about other futuristic techniques? Suppose, and I'm going a bit sci-fi here, we could upload human judges' brains into a machine to create judges that never needed to sleep and never died. Would that be a good idea? That kind of an AI judge future? Even there we have a problem, and the problem is one of datedness. These judges would, as I said, never grow old. Now, would you want a judge from 16th century England deciding your case? Our descendants may very well feel the same way about today's judges. So, artificial intelligence judges, there are some things we can do better, but no, it is not the future.
Thank you so much, Luria. I hope today's seminar has given you an insight into how UNSW Law is leading the way with new approaches to innovation and technology, preparing our law graduates for the legal profession of the future. If you have any questions about our law programs, please visit the law booth in the Advisory Centre. Our staff and students are there to answer all your questions. I really look forward to welcoming you to UNSW Law in the future.